We're live.
Okay, good morning. It is April 1st and Senate Judiciary. We are taking up page 626 and we have Kira Kilburn here to amplify. And if you could just please introduce yourself and then the floor is yours.
My name is Kira Kilburn. I'm a resident of Bergen, Vermont. I want to thank you all for your opportunity to speak today and share my story as a victim of image-based abuse. In 2018, while I was at work, I learned that a video of me undressing had been posted on a pornographic website. Years earlier, in 2012, a trusted college film professor invited me and my sister to participate in a public access TV video for extra class credit. The concept of the video included many outfit changes, which we did in a storage closet that he directed us to change in. He recorded us changing with a hidden camera and uploaded it to the internet. At the time, I was 19 and my sister was 17. The discovery was life-shattering, felt like my future flashed before my eyes, and I'd always heard, what you put on the internet stays there forever. And that fear became my reality and is my reality. I panicked. I take my career very seriously. I have worked in homeless services for the past 11 years and more recently worked for a domestic violence shelter in Chittenden County. I worried I'd be fired and the career serving those less fortunate I cared about so much would be over. Thought about my family members seeing this video, my future partner, and my future children. I went to the police immediately. The detective I worked with told me it was one of the longest cases that he had ever handled, but despite my immediate action and his commitment, there was nothing they could do. The statute of limitations had expired before I even knew the crime had happened. During the investigation, police discovered videos of other young people who recorded in restrooms and changing rooms. They also discovered the perpetrator had searched online the statute of limitations in Vermont. He knew exactly what he was doing. I didn't get the justice that I wanted. I wanted him to be held accountable for harming me and my younger sister and abusing my trust. I wanted my community to know he was dangerous, so no one else would be harmed the way that I was. Instead, I carry the weight of this for the rest of my life while he gets to walk free. I was later diagnosed with post-traumatic stress disorder. It has been incredibly difficult to process how deeply I was violated without even knowing what was happening to me at the time. When I'm in public, I'm still terrified that I'm being recorded. I want people, especially children, to be and feel safe and to be able to trust the adults around them. While this law cannot help me, it can help others, and it can ensure they are protected and able to access the justice. Knowing that would be incredibly meaningful to me. Thank you for your work on this issue and taking the time to listen to my story today.
Thank you. And I'm sorry that all happened to you. Those words aren't strong enough, but I'm sorry that all happened to you. And thank you for coming in to share that story as well. And it's, as you know, this is a bill that was introduced both in the House and the Senate. And we are working on the House bill, which is, it's like, we refer to them as companion bills. And normally when that happens, it's because there's a strong desire to make sure that a policy, regardless of whether it's the House or the Senate, ends up passing. So the statute of limitations was one of the questions that I raised earlier, and well, I think I'll give it to the committee first. Folks, do you have any questions?
Thank you. Get one for the break.
Question, but thanks for being there. If you don't know the specifics, no worries at all. But the statute of limitations piece, can you dive a bit more into that? And regarding the time of the discovery of the offense and how much time had elapsed and how the statute of limitations that we have now basically failed your situation and how we can change that here in this.
Yeah, absolutely. So as I referenced, this crime took place in 2012. as soon as I saw the video, I recognized instantly what it was, where it was, and when it was. But I did not discover it until the fall of 2018. I had figured that it had been recently released because it was brought to my attention through a mutual person. And since then, multiple more people had sent it to me. That was confirmed my suspicions that the video had been more recently released when we had a forensic detective go through his computers and find that he searched hidden cameras and the statute of limitations in Vermont, which is 3 years from when the crime happened. At the time when I went to the police, they thought it was 3 years from discovery and thought that this was a done deal case, but it wasn't. And because in the state of Vermont, my sister who was 17 and while still considered a minor is above the age of 16, it wasn't considered child pornography, which had a longer statute of limitations.
Thank you. That's all.
So it's not really, it's not a question for our attorney or maybe you, but I wonder, like, I understand sort of statutory ability for someone to consent, I believe at 16, and it's a little bit fuzzier than that, but there's no consent here. So I wonder if it should be considered child pornography. It's a minor who didn't consent to this.
I don't know if I fully.
So if the current law would not consider this child pornography because your sister was 17, that to me, the is around consent. You know, we allow 16-year-olds to consent. We allow, I think, sometimes people younger than that, if both people are younger than that. But in this instance, it is a minor, someone under the age of 18 who did not consent. So we're not talking about consent anymore. So for me, this type of thing should still be child pornography.
Yeah.
Did it make more sense this time?
I think so.
Okay.
Maybe a question for Ledge County.
That's what I thought. It might be a question for Ledge Council, but I figured I'd put it into the conversation.
Thank you again, and feel free to follow up with any questions or comments as we work through the bill. We'll have markup, which is where we make edits here and there. I'm not sure how long it'll take for us to get through this bill, but we'll keep working on it. So thank you.
Great. Thank you.
Morning, Sean. Morning. Morning. Thanks for joining us. And if you just want to introduce yourself, and then floor is all yours. Happy to hear your perspective on the bill.
It's Matthew Raymond. I'm the Internet Crimes and Children Task Force Commander from the state of Vermont. It's called ITAC or Vermont ITAC. And our mission is to prevent the victimization of children by people who use technology or the internet. We deal with these crimes all the time. We come across voyeurism as part of our material investigation when we start investigating or examining people's computers. And I can actually speak on the question you had about child pornography. The reason it's not about pornography in Vermont is strictly age-based because the statute under the child exploitations chapter before all that deals with under 16. So consent is not a part of it, obviously, because children can't consent to their commission. And so it's and federally it's under equal to child pornography or child sexual abuse material as we call it now. Federally it's still called child pornography. But in Vermont, it's under 16. So sometimes when we're not able to charge it under Vermont law, we'll charge it under federal law.
And was that possible in this case to charge it under federal law?
Under the prior case that we just had, yeah, it would depend on the what was captured on the recording. So there's different requirements. Like under Vermont law, it has to be a child under the age of 16, either posed lewdly or engaged in sex activity. It has to be the penis or the genitals have to be visible. So, and then it's all the different federally. So it's hard to talk about without the actual facts of the case. Yes, it's possible it could have been charged federally, or it might not have been the credit period, the actual judgment, depending on what the statute. So then it would be charged under voyeurism, but at that time, it was a 3-year statute of limitations. And then, and also important to note from the prior testimonies, like she said, once the, I don't know the case, so, once the computer was examined, his devices were examined, there's multiple victims. These are never one-hit wonders. We never, anytime we come across these, we may have one report, but then so you can get into their devices, you're talking, you know, dozens or hundreds of victims, advice.
When the council comes back on this, and we ask them to bring a comparison of the federal laws around this and the Vermont laws.
It gets, there's a lot of differences, and there's a lot of good stuff in our laws that don't exist in the federal laws. So that,
Yeah, I appreciate that. It kind of boggles my mind that we wouldn't set that cap at 18.
So, well, the problem comes around age of consent.
Right.
When your laws are not, even there, then that, I used to be able to talk about this point, but I forget the case law on this, but, some states that had their child pornography at 18, their age of consent at 16, there was some type of appeal that happened that caused the problem with their child sexual abuse material laws, not matching up to the same age of consent. So, just like with that.
Yeah, I
It
appreciate
gets a
that.
lot more convoluted, of course. Like,
Yeah.
everything, like, it's not that easy to balance.
Certainly not in this building, but I do want to take a little bit of a dive into that and see if there are changes that need to be made to strengthen the protections we have.
So the, what I wanted to speak on today is the part of the bill that's called sexual extortion.
And just to orient us, which page?
Yeah, that's the final, it's right before the statute of limitations. It would be 24 or 28 on my point out. It's the version that had the house.
Our version is 14 pages.
Okay.
Well, which,
I didn't know which one were.
yeah, no worries.
Sorry.
No, which section of the bill?
So it's section 3, sexual extortion.
Oh. Our version is page 10, line 17.
So were the versions the same when it started in the house?
I believe so.
So I have to apologize. I was working off what passed the house. Here, so
Yeah, we do have as passed by the House. I
Okay.
think you have the one that has the red stripe.
Yeah.
And it, I don't know why they do that, but.
Yeah, I don't know. Just
Yeah, so we have the version that is as passed by the House,
okay.
and it's 14 pages.
Okay, so it's, section 3, 2607, sexual extortion. So, sextortion is a serious threat facing our nation's youth and has resulted in at least 38 suicides across the nation that they know of. Historically in ICAC, we've seen sex-based sextortion for a long time. The victims were primarily young females. The conversations were long in duration, from days to months. The perpetrators portrayed themselves as peers, engaging in grooming techniques, making gradual requests over time. Sometimes providing gifts to the victims. The suspects were not aggressive until they actually received the child sexual abuse material, and then quickly turned and threatened to expose it if they didn't get more content. The sole purpose of that was more content, and usually the suspects were US based, and tracking them and arresting them. Then around 2019, we began seeing financial based extortion for the first time. The victims, and this is pretty much nationwide, the victims were primarily male, 13 to 17, very short in duration, a max of hours. Sometimes it happens in minutes. The suspects always portray themselves as a female. The chats are very aggressive, always ask for genitals and face pictures in the same image. The request comes fast. The sole purpose is to obtain money. They usually ask for a lot and then negotiate down to whatever they get. They threaten to expose the child and offer screenshots of their friends' list, their parents and relatives, and threaten to expose the images that they got to these things. Thank you very much. If they're paid, it usually doesn't stop. They just come back for more. It's a lot like, can't tell them, all of a sudden you're sending more. The suspects in these cases are largely, by large, not US based, and the vast majority come from Nigeria, the Ivory Coast, the Philippines, and India. However, we're seeing some US based actors now, mostly like comic actors that they can do it and we track them down. That's them. Also with the foreign actors, they're organized gangs, basically, sometimes with a US based money mule assistant, and the money mule is used to transfer the money overseas to get around some of the protections of the place about money transmission. So around 2022, these cases ballooned, and NetMex saw a huge increase in these reports, and Vermont is no exception. We deal with them now on a weekly basis. More times than not, we have the victims here in Vermont and track the perpetrators elsewhere, again, many times overseas. But we've also had cases where the perpetrators were here in Vermont as well, and the victims were elsewhere. Prior to this law being enacted, as I hope it does, we had to get creative on charging some of them, even using the stalking statute. Again, we deal with victims along Vermont. We also do education, and we have a bunch of stuff that we pass out about do's and don'ts and what happens if there's sex stored. So I had testified in the House on the original versions and advocated for changes that are in this version now. Primarily, I'd asked for it to be changed to a felony with higher jail time available, obviously for extradition purposes. Felony makes extradition possible. And again, these are never one-hit wonders. Normally, they have many victims all over the place. So you'll see in that section, they now have a tiered penalty section that has like it's, I think it's 3 years for an adult, 10 years for a child, and then 15 years if it's serious bodily injury with child assaulting. And that was one of the asks that we had asked them to put into. Again, we deal with these all the time, and they're like, and the big worry is that the child doesn't reach out to a parent or somebody else and happens to like one of those other 30 days where they unfortunately choose suicide. And it's the biggest thing happening in their life, and they can't find a way out of it. These people are asking for money, pressure, and type of threat from about scolding them, and they go into panic mode. It's sad.
I do have one question here, and it goes back to something you had raised earlier regarding the age of consent and making a matchup. And I'm looking at lines 3 and line 6, where it's referring to 18 years of age or older, or under 18 years of age.
Yeah.
And just to preface, I do think it should be under 18,
Right.
under 16. I just want to.
So these, so it's not the same as the child pornography law. This would be, and from my understanding, this would be okay. It's a lot like the section, I can't remember the chapter name, but it's right before the child exploitation chapter that deals with sending images to children. That's the under 18 as well. And that's what big is not about the child pornography or sex. It's about the this exposing yourself to a child that's under 18. That's so I don't think that's an issue.
It's one of
Not an issue for us. And then the statute of limitations, as you just heard, we run this all the time on cases. All the time that we find the lawyers under the current statute of limitation, if it's been over 3 years, we can't charge it. But this would be fair on that. Any, are there throughout the entire thing, are there other changes that you guys were thinking about?
Not off the top of my head. I think I did have actually a question, I think it's subsection E, which is on page 12, where it starts with a person who in good faith and in a timely manner, and so on. My initial, well, I want to make sure that can't be used in such a way against a victim, you know, by somebody who is engaging in sextortion, and maybe there was a sexual trading of images, and then they decided they split up, and then the other person is trying to engage in sextortion, but then they try relying on this immunity clause. And I mean, there's always a million variables, but any thoughts on potentially?
Yeah, so under the current language, I don't have any concerns. So almost always, the initial imagery exchange is consensual. And I say that they're close there because when they're children, they're, you know, they don't really can't consent, but it's always done, you know, in a consensual manner. Then it changes in substitution. Then if they're asking for more imagery, they're storing it for it, or it's money they're storing up for that. So the big thing that we see all the time is threat, because in the financial based ones, which is really what's running rampant right now, they almost never really send the images anywhere. And that's why like our example that we give to everybody is, you know, don't send money. All it's going to do is tell them to keep coming back, and it can block them and don't stop responding. They don't send the imagery, or because they're just purely up for money. So it's the threat of doing it where the real problem is. I mean, obviously, on the other side of this, the first part is built with lawyers, and that's all about people that even possess the stuff that you're hearing from the previous testimony, which is different. But for the sextortion, it's really about the threat.
And the other piece, the other question I had, and this might be a question from the agent's office. Going back one page 11, line 5, the phrase identifiable person. Can you just provide more context on what that means and how a person can be identifiable? Like, is it just the person, or can the background of where they are, where they're located, also be used to assist in determining if they're an identifiable person?
Yeah, I thought there was another section that actually expanded on that. Yeah, I mean, my reading of that would be that they would have to be identifiable from the image. You know, their face or some other way to identify them. But I thought there was a section here that said it was through context, or I didn't know if that was in the definitions or if that had been changed.
Can I jump in?
Oh, yeah.
Maybe
Yeah.
So, for the record, Michelle Childs, Office of Legislative Counsel. So if you're looking at the as passed by House version, not if you have the red line version, it's a different page. But
Okay.
if we're talking about
Yeah, here we go.
dissemination of sexually explicit images without consent in subdivision B2. And so this is current law. Remember, this section is, a lot of it is just kind of moving things around. But so it's current law, but it's moved into this new subdivision 2. I'm on page 8, line 17.
Right.
So for purposes of this section, a person may be identifiable from the image itself, or information offered in connection with the image, And so that has been in there since the statute was adopted in 2015. There is case law on this particular section. Court upheld it as constitutional, did not go into any particular discussion about, you know, they had no issues with identifiable person, and probably you could probably address this because you have a broader scope on working with.
Yeah, that was the section I was actually looking for. I just
Right,
couldn't
is
find
that
it.
we do see
Right.
in both state and federal laws around this identifiable person language. It's not uncommon, and I haven't seen anything that has taken issue with
No, it's
it
not.
being vague or troublesome.
It's not causing us any issues with any of our cases. Okay, it was a prosecutor cases, so.
Just wanted to make sure. Any questions or comments?
I got a quick one. So I'm looking at the bill as presented, from the enforcement aspect of it. Maybe you don't, if you have any recommendations that would make it easier for enforcement purposes of this particular.
I did, but they were all addressed and caged, and the person at the house has all the things that I had requested.
Great. Thank you.
I was looking at my notes, but it's anything else. In the meantime, then we're going to have a question. Yeah, I don't think I have any other questions. It's not at the moment, so, yeah, thank you for your testimony, and I mean, we'll, yeah, we can populate council out, see if there's anything that we need to change. I don't know for this, but, yeah, we can, yeah, let's hear from Ledge Council and just go through this one more time. Were there other witnesses actually that the house heard from that we maybe?
Yeah, testified on several bills, so I'm getting confused on who was really winning.
Yeah, probably a better question.
Yeah,
I
so I
would say, you
apologize.
haven't heard from Dominica?
Yeah.
Yeah, so
I think-
she was asked for today, and what's in the bills, I was wondering here.
Okay, I mean, it depends on your timing of
Yes,
everything,
yeah.
but I think she
She
can
has the
be
same
really,
perspective that I have. on
right,
this.
but if you have certain questions about,
Right, right. Yeah.
prosecution or, you know, certain things that they deal with, she'd be a good witness, but, if you don't.
Okay, yeah, no, I think that, well, I guess, one last question, do you know if she has, oh, no, you're good.
Okay.
Do you know if she has any additional language recommendations? I can also just email her, but.
Yeah, no, I just spoke to her yesterday about
Good with the language.
and she's good with it. We're both good with how it passed the house. It addressed all of our concerns that we had. There was some other issues that I addressed at the house level. I can't remember. There was some language in one of the sections that was taken out, so. So we have no issues with the bill as passed the house.
Okay. Thank you.
So we'll also note for you is that, I worked with Dominica throughout the process, so from, you know, bills introduced, you know, getting the original bill language and then through the process, so I've kept her involved and she's seen all the different facts and innovations.
We're about 6.
I was gonna ask if we have heard from the Center for Victim Services, and here's the witness list.
Page 2, he's on. Except for crime, Jennifer Polk.
Mhm.
Yeah, we can add that to the list here. But yes, let's do markup if there is even anything that we want to change. So we'll just start from section 1, which are the definitions. Are there any I don't think that we need to go line by line with like council, but are there any initial thoughts or recommendations based on all this so far? Well, we all did on section one.
So just as the review, so just to remind people, so the main change with the Boyers and statute in section 1 is it was kind of reworked to separate viewing from the filming, recording, dissemination, all of those things, because this proposal created a different statute of limitations for when there's a recording or you're doing the disseminating a recording. So there's the existing 3-year statute of limitations that would apply under this to the viewing, but then there's the expanded one because of the context of like when you have a recording, you know, might not be discovered until as in the witness has just testified for years, and that might be beyond the 3-year statute of limitations. And I know you had a question about should it be from date of discovery, in Vermont law, you only see that in the context of civil actions. So like med mal, assault and battery, slander, libel, things like that. It will be they start the clock from date of discovery. We don't have anything like that in the criminal realm, and just generally that is not common. There's a distinction because, you know, the whole purpose of statute of limitations, especially in the criminal context, is, you know, that there's kind of a date certain at which you can't be kind of pulled into criminal charges. And, but you can, you know, as you know, you can play around with those statute of limitations. You can set it low, you can set it to have no statute of limitations. And I believe the bill of abuse was from date of discovery. But then in discussions in the House, it seemed as though because there really wasn't any precedent for Vermont law, even though some states are using that in the context of certain like narrow crimes where that they lend themselves to be more likely to not be discovered, you know, for a certain period of years. But it's more fitting kind of with how we do things now. Doesn't mean necessarily that you can't do it. But House Judiciary chose it was kind of a more straightforward approach, is that we do have these tiers for certain lengths of time. And when you're looking at what, you know, and it's in here, one of your sections, I don't want to skip that whole one, but so they slotted it in at the 40-year, which is where you also have statute of limitations for sexual exploitation of children.
Regarding the 3 years for viewing, the issue of viewing isn't in here. It's disclosure and the extortion.
Well, viewing under voyeurism, there is an offense for viewing, and that hasn't changed. So that would just be, you know, there's no recording or filming or anything like that, but that someone, you know, instead of having a secret camera set up to view someone, might be doing that themselves, you know. And so
if there, in that case, if there was a camera and it was them viewing, it was voyeurism, but they were also recording it, but not disclosing it to anybody else or using it for extortion, what would that fall under?
that is still a, here, let me show you the link.
Okay.
So if you look down, let me figure out what it is. So if you look at page 2, you'll see that now B is unlawful viewing. And again, these are all criminal under the current statutes, just rearranged. Then you have page 3, subsection C, we've broken out for unlawful photographing, filming, for recording.
So I get, oh, sorry.
So then if you go to the end of the bill in section 4, for the statute of limitations for the criminal offenses. And you'll see subsection C, which is the 40-year statute of limitations. You turn on the back on page 14. You'll see voyeurism involving photographing, filming, or recording under 2605
Oh,
C.
so
So it
that's
covers
good.
that.
Okay, all right.
And then you'll see 7 is the display or disclosure. So 3 years for viewing, and then anything involving a recording or dissemination of that recording would be the 40 years.
Committee, any questions or thoughts for section 1? Section 2.
Section 2 is on page 7, and that's your disclosure of sexually explicit images without consent. Primary changes there, or if you look at page 8. Subsection B, subdivision 1. Is that you'll see on line 7, removing the word threaten or coerce. And that's because those offenses, those elements are captured in the new sexual extortion section. So those are taken out here. Again, down at the bottom, B2, that's existing law. And you can see where it's struck on line 8 through 11. And it's just brought down into a new subdivision 2. But again, I think it's the Van Buren case that looked at that the statute comprehensively, assessed the third constitutionality, upheld it. There was really no, they discussed a lot about it being one of the elements in terms of making its determination as to why it was constitutional, because they were saying that it was narrowly drawn. And it had all these different elements, and identifiable person being one of them, but there was no concern or anything with using the term or how it was defined in the statute. And like I said, you see that that term identifiable person fairly frequently.
The knowingly mens rea for this.
Mm-hmm.
Can you lay out for the committee what this would look like if we went from knowingly to recklessly?
You'd be lowering the standard. I think the very instruction for recklessly. The voyeurism use is intentional, so use is the highest. Knowingly, was chose here, so a little bit under the intentionally, but recklessly, I have to think about that, about whether or not that would tip the balance in any way, and try to think of circumstances where somebody say, I'll be honest, it makes me a little uncomfortable just from the sense of, I'm not saying that like once the court upholds a statute as constitutional, you can't go back and look with it and change it and things like that. But because these types of statutes really do implicate a lot of constitutional issues, and it's been upheld, and you want to be careful and maybe find different pages of this as to whether or not lowering the mens rea for something like this would they would be comfortable with.
Yeah, and but just a thought, because I'm thinking of, there's a difference between the person who is, sending these images off to their friends, and then compared to somebody who should have known that if they decide to post them on a website, and they come and say, well, I wasn't disclosing it to anybody, I was just, posting it publicly on this website. If they could use that as a defense, even though they should have known that if they disclose these images on a public website, there are other people who want to see them. I don't know if I'm explaining my thought as well as I want to, but
I mean, I think I know what you're saying, but I think it would be extremely hard for someone to argue that by putting something on the internet.
They're disclosing it to everyone.
Right, disclosing it to someone. I haven't heard, I haven't heard any concerns about the knowingly standard. I think the debate that's kind of been out there in terms of, should something be changed or not was around the intent to harm. I think I had testified earlier about, it varies in the different states, whether or not they include the intent to harm as one of the elements. But that's really it. I haven't heard any concerns about the knowingly.
Okay.
And I think, where House Judiciary wound up landing, I didn't want to speak for the advocates, but I think with the advocates too, it was more like, again, there's a statute that's been upheld as constitutional that's working. Is it worth enough to take out that element? You're kind of taking a little block out of the Jenga tower. How does that affect it? Not to discourage you from doing that if that's something that's important to you. You want to hear again, probably from the AG's office, but my recollection is they didn't express any concern about wanting to remove that intent to harm.
yeah, it was just a thought to want to explore the idea for a minute. Just because I know the internet is constantly changing, and with how social media is always transforming and how messages are sent, it just feels like there's a lot of different ways to frame how things get disclosed to other people. So I was trying to make sure all the bases are covered. But I mean, if no concerns have been raised, I'm fine keeping it as it is.
If it's helpful, so for knowingly, I'm just looking at the jury instructions. So state must have proven that the defendant acted knowingly and not inadvertently or because of mistake or by accident. You can find that the defendant acted knowingly if the person was aware that their conduct would cause or is practically certain to cause the alleged harm. And then for recklessly, it's that the state must prove that the defendant acted recklessly. You can find that the defendant acted recklessly if they consciously ignored a substantial and unjustifiable risk that their conduct would cause the alleged harm. The person's disregard of the risk when considered in light of the nature and purpose of their conduct and the circumstances known to them must have been a gross deviation for how a law-abiding person would have acted in the same situation.
So any thoughts on section 2? Section 2? Anything else that you wanted to add, Michelle?
No.
That takes us to
I will just note for you that, in those sections 1 and 2, one of the additions to code was the ability in a negligence claim to for an actual injury to be satisfied by a diagnosis of a disorder resulting from trauma, and that was specifically coming from the case that was discussed earlier by the witness and Chief River saying, hey, we ought to really, legislature should consider whether or not, it's appropriate to, and he was advocating for expansion of it beyond physical injury.
That makes me wonder. So I remember reading that over the summer, the concern or that differentiation between the physical injury versus the mental injury. Would we want to add on line 10, the diagnosis of a mental disorder resulting from trauma? Does that need to be? Would that further clarify?
I don't think it's necessary, but, I don't know, I think it's kind of broader if you don't put that in. That specific language of disorder resulting from trauma was recommended by the network, so I don't know if they have any input on that. I mean, the issue in the case, and looking at it on the physical, is that, you know, they have like this narrow way to be able to get at some type of emotional trauma, like PTSD, if it results in physical manifestations, right? But it's really tenuous and not clear, and they didn't find it in this particular case. You know, again, it's something that's been built through case law, that you do have the ability to change. But I haven't heard any concerns with this particular language, but
Charlie, I guess I'll put you on the spot real quick. Did you want to chime in on that? Do you think there needs to be, this language came from you? Okay. Any thoughts?
Absolutely. Charlie Osterman, Policy Director of the Vermont Network Against Domestic and Sexual Violence. I'm happy to answer any questions, but we feel good with the language as it's before the committee right now.
Thank you. Anything else on that section? I know on page 11, line 16 and 17, regarding accusing a person of a crime or causing criminal charges to be instituted against a person, which I understand. I think we had some conversation about it the last time, but I understand the concept, but I haven't heard the word or the phrase criminal charges to be instituted against the person. Is that, where does that come from?
you know, my recollection was that we were looking at in preparation for drafting this. Again, I was working with the AG's office and the network. We were looking, oftentimes we'll look and see what do the other states have, you know, anybody got some great ideas out there that we haven't thought of. And so I think it was kind of a pulling different provisions from different states. And, you know, this was one that I think we had not originally listed. So in terms of, I think what that could be, you know, I don't know the different scenarios, but I think it would be, you know, not that common under this type of thing, but I think it did raise, maybe we talked about it earlier. You know, there have been some high profile cases of in Vermont lately around law enforcement engaging, you know, who have been charged with certain sexual-based offenses, and there being because of the power dynamic between law enforcement and the survivors in these particular cases, the threat, there was one, I don't remember which county it's in, but it's somebody who's currently charged with offenses was the threat of the perpetrator accusing and reporting the survivor for individual prosecution or, you know, other types of things like that was used as a way to discourage reporting of the crimes.
Okay, so but as it's worded, you don't see any issues with how it's worded.
I don't.
Okay. State's thoughts. Committee, anything else? Section 3.
I'm wondering if, and I saw that Michelle sent the federal statutes, but I'm wondering if we can dive in a little bit to the differences between the federal and state statutes.
Yeah, I can't say that I had time to,
Next time.
to dive into the federal.
I wasn't
law.
sure if you knew, or if the issue of aligning consent age. I don't know if you heard that. I'm just.
Right, I did hear that. That's when I was like, maybe I heard Commander Raymond was correct, is that so in Vermont, the age of consent is 16. So, you know, when you look at certain sexually based offenses, there's this, 16-year-old there's a threshold there. And the offenses that are in the chapter on sexual exploitation of children and within that chapter are the creation of and possession of child sexual abuse materials. It is 16, so it's time to the age of consent. I don't, it's been that way as long as I've been here, and I don't know necessarily, I assume that that's very intentional as to if you wanted to raise the age in the exploitation ones to 18 while keeping, everything else for age of consent at 16. I think maybe you want to talk to the Attorney General's office about that. Right, but
I can certainly understand in an instance where it is all consent, if we've said at 16, you can consent to engaging in sex. I can understand why we would also say it's okay for you to engage in sharing explicit images, but when the consent is gone.
right, and I think for there, if the goal is to try to capture that specific instance, right, then we can craft its own kind of little standalone statute on that, right? Saying so, aside from, I'm just saying that if you wanted to change all of Chapter 64 to be 18 instead of 16, that's a really big change.
Right.
But if you really wanted, I can try to think about.
It's the luring section that will take the hit. Because at 16, they can consent to engage in sexual activity so that when they're luring them online, this was from another state that did the same thing, had issues. And again, Ledge Council better speak of this and mean that's where the problem comes in if you drop everything or raise everything.
And I don't.
The luring section would cause problem would be a problem.
I'm not suggesting that we raise everything to 18 because again, if you can consent to engaging in sexual activity, I think you should be able to consent to sharing this type of thing. It's this narrow piece.
We can craft, I
Okay.
can craft, if you want me to, I can work on something like that and come up with some language for you to take a look at.
So I might be probably misunderstanding something, but how is your concern not covered by what we see on page 12 with the violations for the ages of 18 and under? Starting off lines 4, getting at with the intent to compel a person to produce visual images and so on. No person shall knowingly threaten. So obviously there's no consent there, and it's for under 18.
This only deals with the sextortion piece. I don't believe it deals with the voyeurism or the disseminating of the images without consent.
Right, so I
Or under
understand,
18.
I understand your concern to be what the witness testified to, which is that, so statute of limitations had run on the voyeurism statute, right? There is a longer statute of limitations, 40-year statute of limitations, under sexual, for the whole, all of chapter 61, sexual exploitation program. And so, for the age of 16 is that we can still craft something under this, that if images and I think, I have to think about it and then I would run it by the ages on this, but crafting something that if images are obtained, under the voyeurism statutes, without, obviously that whole statute is without consent, right? That you can create a penalty or you can link it back to the other chapter.
I think that's worth exploring, as long as we make sure to draw on the AG,
Mhm.
just get their review of the language as well. Anything else on this section? So that brings us.
Section 4 on page
Yeah.
13. And so this is statute of limitations.
I'm just sorry, I'm double checking my notes here. Just want to make sure. All right, I'm sorry, good to go. Just want to make sure we didn't have to background.
Yeah.
Section 4.
No worries. So section 4 is statute of limitations, and I've already touched on this a little bit, the changes in C1 and 2 and 3. I was just adding some cross references. Section, you'll see on page 14. So what's being extended from 3 years to 40 years is, as we discussed earlier, it's the voyeurism involving photographing, filming, or recording, as well as the dissemination of those images. There's the disclosure of sexually explicit images without consent, and then the new sexual extortion offense.
Comments, thoughts on this section 4? Yeah. And section, not seeing anything, so section 5 is the effective date. So, okay, so I think the next step then is to look at that idea that Senator Lipowski raised about the AG. Well, the network, get your thoughts on the language. And we're also going to reach out to Jeff Coleman. Is there anybody else? All right, great. Thank you. Appreciate your time. Thank you. Thank you all for coming in. Well, maybe before we go off, generally speaking, priorities for the next 2 weeks, general conversation, bill we want to work on. We've got 8:49. We've got 8:49 and 6:06, which are going to take up the rest of this week. And I'm sure 6:06 will bleed into next week as well as 8:49. So what other areas or bills do you want to? What are folks' priorities?
We have 6:06 coming up tomorrow.
Yeah.
That's a priority.
Can we come back to this conversation later in the week when I've had some time to kind of look at what has come? Because I know I do have some stuff. I just want to figure out where it best fits and just organize my thoughts.
I'm good right now. I just wait till everyone has to, with the priorities. Not more bill to count that. Yeah.
All right, sounds good. We can come back at 10:30 or 8:49. Yes.